Hi guys, Mark Dawes and FPS Limited again, and in this short video I want to talk to you and just reinforce some facts about our Common and Statute Law, which enshrines the right of all people to use force to protect themselves, others or property, and as you know, within that we're allowed to use reasonable force to do so. Well, since the Tony Martin case, there's been a lot of debate and speculation about what reasonable actually means. And many people even today have a fear that if they injure or kill a burglar in their home, for example, that they will be in some way prosecuted and even sent to prison. And we have staff at work worried about this too. However, the law is very clear on this, and the Crown Prosecution Service guidance itself emphasises that homeowners are not expected to make fine judgments in the heat of the moment. Acting honestly and instinctively, in a way that you believe is necessary, is the foundation of self-defence, and even extends to chasing an intruder. That's in their guidance. Now, the CPS guidance goes on to state that you can also use something to hand as a weapon. And many people today have successfully defended themselves and others, even to the point of killing their assailant with a weapon, and they have not been prosecuted by the Crown Prosecution Service. Now, at the moment, there is also a drive by the government to give homeowners more rights with regards to defending their properties, and they're talking about disproportionate force, etc. But to be perfectly honest, those rights already exist. They're already there. For example, let me show you or tell you about an extract taken from The Right of Self-Defence, which was written by Albert Venn Dicey as an introduction to the study of the law of the Constitution of the United Kingdom. And this was written in 1915. In his writings, he tells the story of an eminent man and a very learned judge, Mr. Justice Wills. And related by an ear witness is to the following, this effect. Mr. Justice Wills was asked, if I look into my drawing room and see a burglar packing up the clock and he cannot see me, what ought I to do? Wills replied, my advice to you, which I give as a man, as a lawyer and as an English judge, is as follows. In the supposed circumstances, this is what you have a right to do, and I am by no means sure that it is not your duty to do it. Take a double-barrel shotgun, carefully load both barrels, and then without attracting the burglar's attention, aim steadily at his heart and shoot him dead. That's from an English judge. Now, although this was nearly 100 years ago, we still have protection from killing someone because it exists in our Common and Statute Law, is supported and reinforced by Human Rights Act, and there is lots of legislation to protect people. So why then are some people telling people that there could be problems, if you like, if in defending themselves they actually hurt their assailant? And that quote was taken from a video produced to teach staff in care settings and in the NHS what's called breakaway techniques. Why would someone produce something giving that advice? Well, maybe it's because they want to teach staff how to defend themselves nicely, whilst not injuring vulnerable service users. And to be honest with you, I can understand that. But that statement in itself invokes the law of what's called unintended consequences to apply, which means that by erring on the side of caution too much, so that the degree of force taught and authorised is limited too far, we actually end up creating more collateral damage by explosive situations not being managed as they should be. In such situations, the organisation that is actually attempting to reduce the risk by teaching their staff these nice or these low risk or less effective techniques is actually going to be directly liable for any injury or death that wouldn't have occurred had their staff have been properly trained in the first place. So a bit of a false economy there. Another problem that occurs is when an employee tries to use something that they were taught and it doesn't work, and as a result the employee, in desperation in many cases, does something that they weren't trained to do, which injures their assailant or injures the person they're trying to control. In some cases like this, the employer may decide to discipline them and even sack them, and this has happened in a recent case reported in the press not so long ago. However, all employees have rights, and these are clearly laid out under various sections of various Acts of Parliament, and one is Section 44 and Section 100 of the Employment Rights Act 1996, and it states this: an employee who is disciplined or dismissed shall be regarded for the purpose of this part as unfairly dismissed if the reason, or if more than one, the principal reason for the dismissal was that in circumstances of danger which the employee reasonably believed to be serious and imminent, he took or propose to take appropriate steps to protect himself or other persons from the danger. However, this also doesn't excuse the employer from putting the appropriate controls in place in the first place. So, here's the facts so far. 1, everyone has the right to use force to defend themselves. They have the right to defend others and their property. That can't be taken away. 2, that is a legal right and it cannot be taken away from them, not even whilst they're at work. It's statute right. Now, an individual can even go so far as killing someone, and they will have committed no crime if they had acted reasonably and lawfully. And an employee cannot be disciplined or dismissed for using force, especially and specifically where they were taught techniques or skills that were less than effective in the first place. So the fact is that employers pay out a lot of money in cases where they have been sued because of failing to protect staff. Last year alone, teachers' unions won £30 million in compensation in payouts for teaching staff who were injured at work. Now, how much more valuable will you be if you could help organisations save money by reducing the risk of being sued whilst keeping their staff and others safe? And if you are employed as a member of staff, how much more valuable will you be to your employer if you could save them money too? You might be able to save them hundreds of thousands of pounds. Well, what I can tell you is that we actually saved one organisation £500,000 in 6 months by implementing a new system of work for them. And one model that I'm going to be teaching you in our online course generated £6,000 worth of work in 1 week, and then another £48,000 in further training and consultancy within the following months. Now, all of this was because of the value that they place on the quality of the information that we provide them with. This makes their staff and their clients safer, and it makes their organisation more legally defensible. In the next video, I'm going to show you some of the information that we actually apply that will make you much more knowledgeable than your competitors in the industry, and will make you much more attractive, therefore, and much more valuable in the industry, which in turn will make people more receptive to what you've got to say. That means that if you take information and you apply it, you have good information and you apply it well, and you can save people money, or in fact generate them an income as well, then you are really valuable. And what this whole process is about getting you to have the right information, because that's the important thing. Because if you've got the right information, you can pass that on to your clients. Well, I hope you enjoyed that video. Until next time, stay safe and look forward to the next video, because there's going to be some interesting stuff in that for you too. So until then, stay safe. Thanks for listening. See you soon.